Good afternoon, everyone. Welcome to today's panel, Navigating Alternative Sentencing Through Recovery Courts. I'm Tabitha Robinson, and I'm the co-VP of Membership for the Women's Political Collaborative of Tennessee. Guests, welcome. We are so happy to have you here today. If you enjoyed today's presentation and you want to know more about WPCTN, please visit WPCTN.com, and we would love to have you as a member. And for those that are seeking CLE credit today, thank you for being here. Just a reminder that WPCTN will submit your hours for you to the CLE Commission. Now, before we get started, just a few housekeeping reminders. Please keep your mics and cameras off just to limit the distractions. And now I'd like to introduce today's moderator, Judge Angie Blackshear Dalton. Judge Dalton is judge of Division II of the Davidson County Criminal Court. She assumed the bench after being appointed by Governor Bill Haslam to succeed prior Judge J. Randall White.
Was it Red Rock too?
Dalton was first elected to the Davidson County General Sessions Court in 2006, becoming the first African-American woman elected to a judgeship in Davidson County. She was reelected for a second term in 2014. And prior to assuming the bench, Dalton served in various positions with the Davidson County District Attorney General's Office from 1997 through 2005. In 2010 and 2017, she was elected among her peers to serve as presiding judge of the Davidson County General Sessions Court. Judge Dalton is also an adjunct instructor at the Nashville School of Law and is deeply involved in a host of professional and volunteer organizations. Judge Dalton, it's great to see you here today, and I'll let you take over and introduce our panelists. Thank you so much for being here.
Thank you so much as well, and I definitely appreciate this opportunity for us to talk about something that is so vitally important as it relates to our recovery courts. And just to kind of give you a brief history, in 1997, the Davidson County Criminal Court judges noticed a trend in their dockets consisting of drug-related offenses. And many of the defendants who were appearing on the dockets in criminal court were multiple offenders whose crimes were drug-related, with a good number of the defendants experiencing substance abuse disorder. The criminal court judges acknowledged that simply warehousing defendants with substance abuse disorders had little, if any, effect on addressing the addiction issues. So seeing the jail as a revolving door, and what the judges recognized was that the defendants would serve their sentences and upon release immediately return to the environment that contributed to their addictive behavior. As a result of the concerns observed by the judges of the Davidson County Criminal Courts under the leadership of now retired Judge Seth Norman, the Davidson County Drug Court, popularly known as DC4, was created in 1997. In 2003, the Tennessee General Assembly passed legislation creating the Drug Court Treatment Act in an effort to address and reduce instances of drug use and crimes committed as a result of drug use. The Drug Court Treatment Act generally empowers courts across the state to create drug court treatment programs in order to supervise and support the efforts of participants to achieve abstinence from drug and alcohol use. Over the years, the model and concept of these treatment courts have evolved to place less focus on the drug use and more emphasis on the process of recovery. Hence, moving from calling these programs drug courts to branding them as recovery or treatment courts. With the promulgation of the Drug Court Treatment Act, jurisdictions across the state of Tennessee have established treatment and recovery court programs, including the Davidson County General Sessions Recovery Court Program. Currently, in the state of Tennessee, there are only 2 residential recovery court programs. The Davidson County Residential Recovery Court, or what I've mentioned earlier is DC4, and the Morgan County Residential Recovery Court. And we'll talk a little bit about those in just a moment. It has been my pleasure over the last 3 years to work alongside retired Judge Seth Norman to establish the Women's Residential Recovery Court, which we hope to have up and running. I'm almost afraid to say it because I'll jinx myself, but we hope to have it up and running within the next month or 2. We've been working very feverishly over the past 3 years to get the Women's Residential Recovery Court, which will operate much like DC4, which Judge Smith will talk about in just a few moments. It has definitely been a work in progress and something that that we expect, as I said, to be open in a couple of months. These residential recovery court programs are designed as long-term residential programs for adult nonviolent offenders with substance abuse addiction. The programs are designed to receive participants from across the state of Tennessee. The goal is for participation in the recovery programs to address substance abuse disorder rather than serving a sentence in the Department of Correction. So to move on to talk about the recovery court programs that we have here in the state of Tennessee, and particularly here in Davidson County, I want to introduce to you my colleagues and my friends, Judge Jennifer Smith and Judge Gil Robinson. First, Judge Jennifer Smith is judge in Division 4 of the criminal court for the 20th Judicial District, serving metropolitan Nashville and Davidson County. She was originally appointed in 2018 by Governor Bill Haslam and was elected to complete the term in 2020. Before her appointment, Judge Smith served for many years in the Tennessee Attorney General's office. During her time as a practicing attorney, she handled criminal law cases at all levels, including both prosecutorial and defense perspectives. She has argued 3 cases before the United States Supreme Court and numerous others in the state and federal appellate courts. She received her undergraduate and law degrees from the University of Mississippi and a Master of Science in Strategic Intelligence from the National Intelligence University in Washington, D.C. As a state trial judge, Judge Smith presides over trials and related proceedings involving all manner of criminal cases. She is also the presiding judge, as I mentioned just a moment ago, of the Davidson County Residential Drug Court that we affectionately call DC4. Judge Smith has more than 22 years of military service, currently serving as an intelligence officer in the United States Navy Reserves. Thank you so much for your service, Judge Smith. She lives in Nashville with her son, Daniel, who is a junior at Hume Fogg, and she has an adult son, Thomas, who is also on active duty in the United States Navy. Thank you, Judge Smith, for being here. I also want to introduce you to Judge Gil Robinson. Judge Robinson is a native of Nashville, having graduated from the University of Tennessee and the Nashville School of Law. He's served in private practice from 1985 until 1980 and was elected in the Davidson County General Sessions Court in 1990 and has been re-elected each term since then. He served as the presiding judge of the Davidson County General Sessions Court from 1994 through 1995, and also as a judge on the Court of the Judiciary from 1994 through 1999. Judge Robinson is active in a number of organizations that support not only the bar, but other manners of our community. The Nashville Bar Association, the American Bar Association, the Tennessee Bar Association, the American Judges Association, the Jerry Baxter Masonic Lodge, and the Scottish Rite. And he's also a Scottish Rite Mason. He is married to Miss Nancy Oakley, and they together have 4 wonderful children. Thank you so much, Judge Smith and Judge Robinson, for both being here. I have already introduced you, given us a brief biography, but what I would like for you to do at this point is talk a little bit about the role that you serve in the respective courts over which you preside in terms of the recovery court. So Judge Smith, tell us a little bit about your role as the judge who presides over DC4.
Thank you, Judge Dalton. Yes, so DC4 falls within the jurisdiction or falls under the supervision of Division 4 Criminal Court. As Judge Dalton mentioned, it was started originally by my predecessor, Judge Norman. It originally began as an outpatient program, but Judge Norman realized pretty quickly the challenges, and I know that Judge Robinson experiences with outpatient. There are limitations that you have when you're trying to deal with individuals who are still in their same community, in their same environment. And one of the things, the benefits of having a residential program is you remove individuals from the people, places, and things that tend to trigger the types of behaviors that lead to substance use disorder. So the residential program, the residential aspect of it is critical to the success of DC4. As the presiding judge of that, really my function is twofold. First, presiding judges, and let me just say, sort of a recovery court or a drug court, it's not a separate court. It is a specialized docket that that any judge with criminal jurisdiction can have a recovery court, can preside over a recovery court, so that what's involved with that docket is, and it for us, I see the residents of DC4 at least every other week. So every 2 weeks, I have a status docket or a compliance docket at which I interact with each one of the participants and discuss where they are in the program, how they're doing, where they're doing well, how, areas that they can improve. But the judge of a recovery court sort of serves as that the treatment team leader, the presiding judge. They have many functions, actually, because the key difference between a recovery court and a traditional court is the non-adversarial nature of that proceeding. It is a situation where the judge, the prosecution, the defense counsel, the probation officer, the treatment team all collaborate and come to one mind before at a staffing before the docket. And then at the docket, everyone is, you're presented with a common front. It's very different from an adversarial nature in a courtroom. So the other difference is I also have direct interaction with each resident. I don't, the residents don't talk to me through a lawyer. They talk directly to the judge, and they interact directly with the judge, in a very open manner. We expect them to be honest. We expect them to engage with the court and to engage with their treatment team. So that's one aspect of the role, is to sort of lead that treatment team during the staffings and to assess and monitor the compliance and the progress of each of the participants in the program. And then the other component that I have as a presiding judge of a residential program is to oversee that aspect of it. There we have a multi-acre campus off of County Hospital Road. I have a director of the residential program, but the judge ultimately supervises that particular facility, monitors the budget, approves staffing decisions. So there's that component as well. I also have a third function that is one of my least favorite functions, and that is going hat in hand to the legislature and asking for money every budget cycle, because we never have quite enough money to do the things that we want to do. So there are a lot of different functions that the presiding judge of DC4 has to undertake on top of the standard criminal court docket.
Okay, thank you so much, Judge Smith. Judge Robinson, I'd imagine that although these are two different recovery courts, yours is you have jurisdiction over the cases in the Davidson County General Sessions Recovery Court. But I'd imagine that your role is somewhat similar to Judge Smith, but I'd imagine that there are some differences. Talk about what the difference between what you do with the General Sessions Recovery Court versus what Judge Smith does.
Well, my role is basically the exact same as Judge Smith. We have a docket every week, depending on what phase the participants are in. I'll see phase 1 every week while they're in phase 1, and then phase 1 and 3 and 2 and 4. But we have a docket every week. We have the same procedure as Judge Smith. We have a staffing where the team meets, the probation officers, the district attorney, the public defender, representative of law enforcement. We have a mental health co-op there in court. We have our drug testing, AverHealth in court. We have our traditional housing team, the folks from the different transitional housing that are there for staffing. So my role is as the team leader of the team. And then once we do staffing, we are again all in agreement as it relates to when the participants come in and we interact with the participants. I think the only difference is our recovery court has a MOU with the Tennessee Foundation for Change, which is a 501c3 corporation that I don't have anything to do with, thank goodness, and I don't have to involve myself with the operation of the foundation. I have the role of asking the county for money, and a lot of our money comes through the federal government and the state, but funnels through the state to the foundation. The foundation runs our outpatient treatment program at the Tennessee Foundation for Change. Therefore, if a participant needs inpatient treatment, we have partnership with Buffalo Valley and Samaritan Center and some other inpatient treatment facilities. And then, of course, they get their outpatient treatment, and everybody gets the same outpatient treatment at the foundation. So basically, my duties are just like Judge Smith's, I guess the most important is, as Judge Smith said, our interaction, which is a little bit different than sitting on the bench and hearing cases, because it's not adversarial, to interact with our participants that are on their road to recovery.
Okay, thank you so much. We have attorneys from across the state of Tennessee who are participating in on this CLE today, and I'm sure that many of them are going to have some questions about how their clients can get into either of the recovery court programs now. And I know that it's going to be different because of the jurisdiction, the difference in jurisdiction that DC4 has versus what Judge Robinson has. So Judge Smith, tell us a little bit, if number one, if an attorney in Davidson County has a client that they think would be suitable for treatment with DC4, what are the steps to get their clients in? That's number one. And then the other thing that I want to ask you is, what about an attorney who has a client, say, for instance, in Madison County, which is Jackson, Tennessee? Can a participant from other jurisdictions participate in your program? And what is the process of getting them in the program?
Yes, I'm a state trial judge. I have statewide jurisdiction. So anyway, well, just the other thing about my court versus Judge Robinson's court is that the participants in DC4 are convicted felons. So we're basically the folks that come to DC4 are really this is, for many of them, their last opportunity to avoid Department of Correction time. So a lot of them have participated in other drug courts in their home counties and have not been successful, and or have gone to other treatment facilities and have still come back into the criminal justice system. But the process is the same, whether you're from Davidson County or from another county. We take referrals to the program from other courts. We will screen people at the request of a district attorney or of a defense counsel, but there are certain criteria to admission to the program that are required just for us to be certified as a drug court. Statutorily, the recovery court DC4 is only available to nonviolent offenders, and that's a statutory prerequisite. And then, consistent with the drug court principles, which are through the National Association of Drug Court Professionals, and which have actually been codified in our drug court statute, that we serve a population that is considered high risk, high need. Well, high need meaning people with severe substance use disorder as determined by a standard screening tool, and high risk meaning these are individuals at high risk of reoffending. So there is a standardized tool. So when we get a referral, whether from Davidson County or from any other county, we have an individual on our staff who will go to that person and actually administer this screening tool to see if that individual meets our admission criteria. And as well, we'll also look at their criminal record to make sure that they're eligible in that way. And we also look at how much time they have, because our program, the DC4 program, is a lengthy program. These individuals are going to be in residence for generally around a year. It's possible to finish the residential program as early as 9 months, but that is rare. We have, you would expect at least a year, and sometimes it could, be as long as a year and a half, depending on each individual, because this is an individualized assessment. Everybody's not on the same track. Our phases are the same, but people progress at different rates. And then we have a 9-month follow-on aftercare program. So you've got to have a significant amount of time. If you got less than 4 years, 3 years, we generally won't accept someone with that amount of time because they won't have time to get through our program. Now, with the only exception being we have a number of beds, 4 or 5 beds we have set aside for our local mental health court, which is run by Judge Blackburn, a General Sessions Judge Blackburn. Those individuals have shorter sentences, and that program is shorter. And so their stay in our program, they complete the residential program, but they just don't do our aftercare. When they finish, they go back to Judge Blackburn. But that's pretty much the process. It's the same. And again, we do accept referrals from across the state. They generally, we have certain judges that send a lot of folks to us just because they're used to dealing with us, but we're open to all counties across the state.
And the referrals from across the state, are they from courts or are they from recovery courts in those other jurisdictions, or is it a mixture?
It's a mixture. It is a mixture. We've got a lot of times we'll get them from a recovery court where they have individuals that haven't been able to complete those programs. So where those judges believe that a residential, more intensive residential program would be more appropriate.
And I wanted to make sure that we reiterate that, because DC4 and Morgan County right now are the only 2 long-term residential recovery courts in the state of Tennessee. So those who may be coming from other recovery courts do not have that intensive supervision. Is that correct?
That's correct. They don't have that residential component. Yeah. And the difference between Morgan County, Morgan County residential recovery court is an all male facility. Yeah. And so that's one difference between Morgan County and DC4. DC4 does accept, we have a female program and a male program within our same facility. The other difference between Morgan County and DC4 is that Morgan County does not have an aftercare program. Mm-hmm. So those individuals will, when they finish the residential component, if they're from Davidson County, they will then participate with our aftercare folks. I'll supervise them during the aftercare component program, a part of their program. If they are from another county, they'll just go back to that county and be supervised there when they finish the residential program.
Okay. Now, Judge Robinson, I want to talk a little bit about how participants are referred to and accepted into the court over which you preside, the recovery court over which you preside, because again, I think there are some jurisdictional differences. So if you could talk a little bit about those jurisdictional differences, and then how referrals are made to the court over which you preside, and talk a little bit about those steps.
Well, unlike the trial courts, I only have county jurisdiction, so my jurisdiction ends at the end of Davidson County. However, we have accepted participants from other counties, and we have accepted participants from the state trial courts here in Nashville. sometimes those are challenging in the event one of our participants needs to be sanctioned. But all in all, we can supervise them when it comes to termination or some type of sanction. We have to deal with the state probation and with the trial courts. I have found over the past 4 years, it's worked pretty well. I just can't terminate anybody from recovery court if they're out of the state trial court. So I have to kind of work with the state probation office. But on misdemeanor sentences, we are basically a misdemeanor recovery court. Two ways really that we receive participants. Just like Judge Smith said, some of our participants, it's the last ditch effort. They've been on probation. They haven't been successful. Their substance abuse disorder has caused them to either be re-involved with the criminal justice system or failing drug tests, and there's a probation violation. So the defense counsel can make a referral on a probation violation case to our drug court probation officers. The same situation, they are screened. We are a high risk, high need track of treatment. We are in the process, and I may be jumping around a little bit, but we are in the process of hopefully getting started a moderate to low risk, moderate to low need track, kind of like a DUI court. Not there yet, but that's something that's coming. So we take folks that have probation violations that have already been sentenced. Another way is that the defense lawyers, if they can get an agreement with the district attorney, we will accept cases open without a conviction or without a plea. And they come over for the supervision of recovery court on open cases, agreeing that a condition of their bond be that they abide by all the rules and regulations of recovery court. So the referral just needs to be made to our director of recovery court here in General Sessions Court. The participants are screened. If they meet the criteria of high risk, high need, they're accepted into the program based on availability of how many participants we have. And we like to keep them, and the majority of time, can they finish in a year? Yes, they can finish in a year. We like to keep them 18 months to 24 months. And a lot of times on open cases, if they have 3 or 4 open cases, or they have a couple of misdemeanor convictions, run them consecutive, where we can keep them at least long enough to hopefully successfully complete the program.
Thank you so much. There are a few questions in the chat that I definitely want to get to, but while we're on this topic, I want to get to one question, and then I'm going to go to some of the other questions that are in the chat. And I think, Judge Smith, this question is for you. How can a defense attorney submit an out-of-county referral to DC4? What does that process look like?
So that the out-of-county request, it would run through our screening team. Alaric Pruitt does all of the intakes, and that his name and contact information should be on the website. And he's the initial point of contact. He works with all of the out of county, works with the courts, and has good connections across the state. And so he would be the initial point of contact if it's a situation that if the individual meets all of the criteria, then at that point we'd send out our screener to do the assessment. And then only after that assessment approves the individual, then generally it would then go to the trial judge, who would just, the way it works is they would put them on community corrections, and as a condition of community corrections, they would be referred to DC. They would have to participate in DC4, and the case would then be transferred to Davidson County, and that individual would physically come to Davidson County at that point. And I would assume jurisdiction over the individual pursuant to the transfer order while they're here at DC4.
Okay, great. I want to get to another question that's in the chat, because both of you talked about how you had to go to your respective legislative bodies to everybody's favorite process in almost everything. We go to our respective legislative bodies, where there is a need. And I think that, this is it's so critical. These programs are so, I believe in them, which is why I am more than happy to preside over the Women's Residential Recovery Court, because I think that they do provide us more than just a service to those who participate, but I think it also benefits our community as a whole in a number of ways. And one of those ways, I believe, is financially. One of the questions, so the questions are somewhat related. One question asks, what percentage of people who come into the criminal justice system with drug arrest and addiction issues are served by specifically DC4? Would you by chance have that number or that statistic, Judge Smith?
The percentage that come into the system?
That come into the criminal justice system with drug arrests and addictions, but that are served by DC4. Do you have a number?
Well, I don't have a number, but I can tell you that it's way fewer than needs to be, because we're obviously limited by our bed space, and it generally there is a lengthy, sometimes up to a 6-month waiting list to get into to DC4 just because of the high demand. That's one of the reasons that Morgan County was opened up to sort of address that demand. That's one of the reasons that the women's facility obviously is coming online, because there is, I don't know a percentage, but just anecdotally, as a sitting criminal court judge, I can tell you that it is a very high number of individuals who come in on probation violations or other matters that involve substance use disorder, that involve, and there are often, if folks don't go to DC4, I'm requiring that they go to other residential programs like Buffalo Valley, just as part of their probation. So it's a very high percentage you see just on a daily basis. I don't have the precise figure. I just know it just because I see it every day. As I know you do too, Judge Dalton and Judge Robinson.
Absolutely. And I'm sure that Judge Robinson, because in general sessions, it's such a high volume court. And a lot of those cases, because a lot of those who have the substance abuse disorders are usually charged with misdemeanors, you see a greater volume of cases there in general sessions court, Judge Robinson. You may or may not have a number for us, but I guess a good number of them we would like to see diverted to a recovery court program, but as Judge Smith pointed out, because of space, would that be an issue?
Excuse me. Yes, the best practices dictate that a probation officer should only have 45 participants to supervise during their participation in recovery court. I have 3 probation officers, and what's that, 130, lawyers aren't good at math, but I can assure you, if I had 20 probation officers, I would have enough business out of the General Sessions Court here in Davidson County to serve the folks that are becoming criminally involved because of their addiction. Number-wise, I couldn't tell you. We're a high-volume court, as you're well aware of, from having been a General Sessions judge. But I sure could use a lot more money to hire a lot more folks to help a lot more people with their substance abuse disorders.
Yes, yes. And I guess while we're on this topic of money, during the introduction, I talked about how back in the mid to late 90s, and Judge Robinson, you were in General Sessions Court at that time, and I'm sure very familiar with and recall what Judge Norman, the process that he took to execute and start the DC4 program. But that stemmed from the concern of, and I think the term that I used was the revolving door. of those with substance abuse or substance use disorders who, when they serve their sentence, and usually a matter of a few days, and they're back out into the environment that contributed to that, and then they're right back in jail. So I guess that one of the questions that is asked in the chat, which I think goes to this point, is what is the cost per day to have an individual in DC4 versus the county jail? Does anybody have any feedback on that? Is it more cost effective for people to participate in a recovery court program?
I can
warehouse them.
Yes, I can speak directly to that because this is part of my sales pitch to the legislature every year. It costs $76 a day to house individuals in the Department of Correction. It costs $35 a day to house them at DC4. So there's a $41 a day difference. Because of our budget, we've got we're a grant funded program. We've got a total of $1.7 million annual budget, but with our budget, we try to limit the number of individuals in our facility to around 70 residents, just because of overhead and food and those types of things. But even at 70 residents, which is not our facility capacity, we have we could house up to 100, but limiting it to 70 residents with that $41 a day difference, you've got a $1,447,550 savings to the state per year at our current capacity of 70 individuals. If we were at facility, we would be $1.5 million savings at our facility capacity. So recovery courts save money. I say this over and over when I speak about it. They save the state money. They save lives, real lives and families. So, and to your point, Judge Dalton, they stop that revolving door of people coming back over and over and over again, which is again, just accumulating costs and in the courts and other places. So, but definitely you can see a clear difference at that $41 a day difference.
And Judge Robinson, I know that the Davidson County Recovery Court is not a residential program, but you partner with some of the organizations here locally for residential treatment. Are you able to talk about the numbers, financially, the savings to the county when it comes to the recovery court program?
Apparently, our sheriff has better facilities than the state, because our sheriff tells me that it costs $103 a day to house an inmate locally here in Davidson County. That's the numbers that he has given me. So $103 times a 11 months and 29 day sentence times X amount of people is saving the city millions of dollars a year. We're a little bit different. Well, we have some federal funds, we have some state funds coming in, but our participants are, I don't have a residential facility, so they're in transitional housing. So they're paying for that. They're required to work. We do supplement the drug testing with our participants. The total cost versus incarceration and participation in recovery court, I don't have a figure. I can get that for anybody that wants it, but it is a tremendous savings, not only from keeping folks out of jail, but for the community in general. We have got to quit criminalizing addiction. We have got to quit locking people up because of the disease of addiction. Our communities are safer if someone is in recovery and not in active use in a lot of different areas, not only from their criminal involvement with crimes such as theft to support a habit, driving under the influence because of their addiction, by by allowing folks to participate in recovery courts and rebuild their lives, not only save money for the taxpayers as it relates to incarceration, but save money for the taxpayers because if we can keep folks from coming back into the system, that's cost effective there with all of the resources that cost in the criminal justice system.
Yeah, and that is so important. It is so important. Like we said, not only are we, saving the city and the state money, but we're saving lives. And that is what is paramount and what is so important. I want to move to talking a little bit about, and both of you have touched on this a little bit, but I want to kind of delve into a little more specifically about what happens once an individual is in the program. Once they're in the program, now there are success stories. Unfortunately, there are some unsuccessful results. And that's just the reality of it. And I think that we have to accept and understand that. But with that said, I want to talk a little bit about what happens once a participant is in the program. What do they do? You talked about the various phases. When they're successful in a phase, what happens when they're not successful? Are there sanctions? How does that process work? And who wants to, Judge Smith, you want to talk a little bit about that?
Sure. Certain DC4 is a phased program. So the number one thing that when someone comes into the program, the first thing is they don't come into this program off the street. We take people directly from jail. And we transport them to DC4. The residential component of the program is broken into 3 phases. Phase 1 is really the period where you're sort of orienting individuals into the program, especially the first month or so. It's a very restrictive environment for the individuals. There's no visitation. They're wearing a jumpsuit. They're sort of a prison looking outfit to sort of to separate them and to sort of identify them as individuals who are being oriented and assessed. They go through their formal assessment with the various counselors to see where they are and what type of treatment they need. And they're really just getting oriented to the rules. The DC4 is a very rigid program, a lot of rules that a lot of folks are not used to following rules. If they were good at following rules, they probably wouldn't be in DC4 to begin with. But that program lasts anywhere from that phase lasts anywhere from 3 to 6 months. And as they move through the phase, they're able to gain more and more privileges. And also, in addition to participating in group sessions, individual counseling sessions, individuals are all assigned a job at DC4. DC4 is completely self-sustaining. We handle all of our janitorial services. There's a community garden. There's a wood pile, wood shop. They sell firewood for some extra money for the program. So everyone is assigned a job. So they have to do that. Some work in the kitchen. We don't have a kitchen staff. The DC4 residents cook all the meals. So they'll have a particular job. They'll stay in that phase for about 3 to 6 weeks. Then they will, once they're ready to go into the phase 2 program, that's considered our stabilization and rehabilitation program. Again, they're working their treatment plans. During phase 2, they're allowed to go to outside NA meetings. They're allowed to have passes for visits during that phase. Again, anywhere from 3 to 6 months, they may be in that phase. And then finally, phase 3 is the point at which the individuals will still be living on campus. They will move into a 2-person, almost dorm-like rooms. In phase 1 and 2, they're living in a sort of a barracks type situation with the other residents. In phase 3, they're allowed to begin to work. They're required to work off campus. And so they'll go look for a job. They'll go to their job every day. They're required to work a certain number of hours. I want to say it's around 540 hours total to complete that phase 3 program. And then once they finish with that, then they will graduate into the aftercare program where they'll go into a transitional housing, they call it a halfway house, but it is a transitional, they'll go into a sort of sober living houses and begin that aftercare program, which lasts about 9 months. But as they're going through this, everyone's progress through the program is not a straight line. I mean, they mess up, they break the rules, especially in aftercare. We'll have some relapse. They might test positive on a drug screen. A part of, one of the components of drug court is this notion of, responding to compliance or non-compliance. Individuals who are compliant with their program, they're doing everything that they're supposed to do. We'll try to give them incentives. And that could be anything from just praise from the court during the docket to small things like small gift certificates, like for some from McDonald's or something we might get from our support foundation, or privileges, an extra phone call or some time off from the community service work at the residence. So we try to be a little bit creative with the incentives, but there are also sanctions if someone messes up. And again, it could be an admonishment from the court, from the bench, stemming all, it could range all the way to, going back into a jumpsuit, removing privileges, to actual jail sanctions. And so that's part of there is a continuum of sanctions, a graduated system of sanctions depending on the severity of the infraction or the frequency of the infraction. But the jail sanctions could last anywhere from 7 days to 14 days up to 30 days for a very severe violation. But that's part of those, that ongoing judicial interaction and immediate responses to participants' compliance and non-compliance is one of the things that one of the components of a drug court program.
And Judge Robinson, what about with the recovery, the Davidson County Recovery Court?
Our program consists of 5 phases. Basically, kind of like Judge Smith's, they progress at their own pace. The participants, when they're screened, if they're in need of inpatient treatment, we'll get them into inpatient treatment. When they're released from inpatient treatment, they come to us. And depending on their status, I guess, could they live at home? Potentially. If home is conducive with recovery, then yes, they could stay at home. If home's not conducive with recovery, they go to transitional housing. Whether they go to inpatient or IOP, they begin immediately IOP. Phase 1 and phase 2 come to court every week. And then phase 3 is stepped down to every other week. Phase 4 is once a month, and phase 5 is once a month. Kind of phase 5 is kind of treated like an aftercare program where they are stepping down, getting ready to, even though they're in the community, but to re-enter the community without the supervision of the court, which is a very, very critical stage. So they progress at their own rate, and just like Judge Smith said, while they're participating in recovery court, we have incentives for the folks that have exhibited recovery and their participation in the program. And then we have sanctions. And, we try to look at best practices and proximal goals versus distal goals. Proximal goals are something that we all have control over, i.e. showing up, telling the truth. If you violate a proximal goal, it's a higher sanction. But we are very creative. Our team is very creative with depending on the severity of the infraction. I don't punish people for relapse. I only punish them if they lie to me about a relapse. I think that as judges and overseeing recovery courts, like I said, we got to be careful about criminalizing the addiction. When we receive folks into the program, starting out, they may not have the ability to stay clean and sober. So working through the phases, and while they're going through the phases, we have IOP, we have relapse prevention, we have grief counseling, we have trauma counseling. They're required to make their mental health appointments. So a collaboration of everything that's going on in their lives, we are trying to provide them with services that will help them be successful in getting clean and sober and getting into recovery.
You both have talked about I guess my term, but you'll know what I'm talking about. I guess the matriculation period, the time that they're in the recovery court program. Because not only for the residential program, you have, I think, and correct me if I'm wrong, Judge Smith, I think about 12 months. And then you have aftercare, and then Judge Robinson, I know that you will keep people for up to 24 months, if I'm not mistaken. Why is that time frame so important? I mean, if I'm looking at, for an example, if I'm in General Sessions Court and I'm looking at, I have a B misdemeanor, drug paraphernalia. No, that's an A misdemeanor, isn't it? Let's say I have let's say
criminal trespass, a B misdemeanor.
Trespass, a C misdemeanor. Why don't I just serve my 30 days? Why do I need to go to you for 24 months?
Well, most of the time that's not the case. Most of the time they are class A misdemeanors, and many of them have several class A misdemeanor charges: theft under 1,000, possession of control, possession. A lot of different, most of them are class A misdemeanors. And if, the participants got to want to participate. The participant has got to want to address the issue of addiction. They've got to want to get clean and sober. Because it's not a walk in the park. You're exactly right. If a person doesn't want it, go do your 6 months, go do your 1129. And I've had folks that are screened from recovery court and say, oh no, that's way too difficult for me. I just serve my sentence. And, those folks are not at a stage, they're not at their bottom to really want to reestablish in their lives and to get clean and sober. They got to want it. It's not an easy program.
As we develop the Women's Recovery Court program and looking at, I'm and I've talked to both of you about it, just kind of, picking your brains and learning what, in addition to the best practices that's established by the National Association of Drug Court Professionals, but I think also just in our real life experiences as judges and what we see day to day from the bench and the people who come before us, I definitely pick both of your brains as we develop this Women's Recovery Court program. Judge Smith, you want to add to what Judge Robinson has said in terms of why the time frame is so important?
I think the one thing, and I think, well, for us, one of the big differences between DC4 and Judge Robinson's court is that the folks that are coming to me in DC4 generally have a significant amount of potential prison time hanging over their head. Every single person that comes into criminal court that's got some kind of drug-related use says they want recovery. They want treatment. Everybody in criminal court says, I want treatment. The problem is, what they really want is to not be in prison and not be in jail. You can say I want treatment all day long. So for us and for me, I think that the length of the program is important, just because you see people change. Everyone comes in and says, oh, I've heard DC4 is a good program. I really want to be here. Well, they get into DC4 the first few weeks and they think, I don't know if I really want to be here. This is not what I thought I signed up for. It's a lot harder than I thought. And you really have to have that time. Number one, just to allow their bodies to be clean and to start, living without, poisons in them. And you see, so that time is necessary. I literally see a change just physically from when people come into the program to when they graduate, but also just mentally and psychologically. Just you see people that come in and they say all the right things, but they're just not there. They just don't want it. They just don't. They're just saying it because they need to say it to get out of the situation that they don't want to be in. But what I've seen is you see a lot of resistance early on, but just over time, you begin to see a change in people's attitude, a change in people's desire, a change in people's motivation. And that's to one of the most rewarding things of the program, is to see that change. And I've had people that have started, and I thought, I don't know. I don't know if he or she's going to make it. And then, over time, you start to see a change. And I actually like to mention that to people at the dockets, that especially toward the end of their program, when I say, I'm just so proud and pleased to see the change. But I think the time is necessary for that.
I have enjoyed over the years, and I've done more with Recovery Court because it's usually here in the building. I've not had a chance in recent time, although I've been to DC4s, the graduations. That I have to admit, it brings tears to my eyes at the graduations. We're down to about 2 to 3 minutes. Just as you wrap it up, as you think about what you have, what you've presiding over the courts, what does it mean on graduation day, Judge Robinson?
Well, I've been on the bench. I started my 31st year this year, and I have to say.
And you don't look a day over 25.
Oh, you're wonderful. It has, my participation, being allowed to participate in Recovery Court, has been the most rewarding part of my 31 years on the bench. The reason being is, like Judge Smith said, we have the opportunity to see folks transition and transform their lives and reestablish relationships with parents and children and be productive in the community and not be criminally involved. It is the most rewarding thing personally that I have been involved in.
Great. Judge Smith?
I completely agree. And graduation is, we try to make it special. We make it a special event. I had Judge Robinson actually was one of our keynote speakers at a graduation not long ago. But then the residents are proud of it. Their families come, we stand around and take pictures afterwards. And I'm always proud of them because it is a tough program. And, it's not the end of the road for them. Recovery doesn't end when the drug court ends, and they know it. But it's a step. It's a step.
Well, let me say that I thank each of you for what you do, not only on the bench day to day, but what you do, because I don't know that people understand this. This is time that you give, and not that you do it to pat yourself on the back. And I know both of you, and I know that that's not why you do it, but you do it because you care. You care about the people who come before you in the recovery courts. You care about our community. And I just want to say, just in case I haven't said it, thank you for the work that you do with the recovery courts. And I am pleased to hopefully within the matter of a month or two, fingers crossed, y'all, I can join you in those efforts. And I trust when I say I will definitely be knocking on your doors as we go through this process. But again, thank you. It is now 12:59. I think that the top of the hour is here. Judge Robinson, Judge Smith, thank you. Thank you to the Women's Political Collaborative for inviting us to be here, and for those who attended, thank you. The Women's Political Collaborative will submit your CLE hours for those who are requesting it. Tabitha, is there anything else?
That's it. Thank you so much for being here, everybody.
Thank you.
Thank you.
Thank you.
guess